Next case we have on the docket is Poole versus Schneider.
Good morning.
Good morning.
May I proceed?
Yes, you may.
My name is Mark Lang. I'm attorney for the appellant Erik Poole. I'll reserve 3 minutes. While I was not counsel below at the trial level, we are largely going to rest on our briefs here today, and I'd like to thank Stephen Jacobs of my office who participated in the crafting of those in an excellent fashion, I believe. I want to start at the end of the case, really, and ask that at the very least this court remand the case for a final hearing and entry of a global judgment and a final fee hearing. There was no evidence provided by either party in the limited 2-hour final equitable distribution trial regarding fees incurred, costs incurred, or affidavits or any expert testimony. All that's in the record is a $30,000 lien by Mr. Poole's prior attorney, Clayton Simmons. And paragraph 7 of the final order appealed from here today says that on page 3, record 4574, that Florida Rule of Appellate Procedure 9.130F prevents this court from entering a unified final order formally disposing of the case as a whole. And in paragraph 9, Judge Beck goes on to retain jurisdiction. Again, I did not file the notice of appeal on this order or the other appeals on 2 other orders, so I personally don't understand why a appeal wasn't delayed until a final judgment was entered. In any case, in addition, there was a partial final judgment on December 21, 2012 on the validity of the prenuptial agreement, in which on the last page of that, page 1679 in the record, Judge Beck writes, "This court reserves jurisdiction, including respondents' claim for alimony and attorney's fees." There was a stipulation and a partial final judgment on the dissolution of marriage, which was entered on August 26, 2012, and the notes from the, I don't know who wrote them, at the bottom of the first page, page 1655 of the record, it says, "Case to remain open until full final judgment." And then with respect to a stipulation signed by counsel for both, page 1670 in the brief, it says, "The parties agree that the final trial of this matter, former husband may claim that additional fees were due and or that additional fees may have been incurred since this stipulation." And finally, the wife in her answer brief on page 1, paragraph 3, concedes that no unified final judgment has been entered disposing of the case in its entirety. So, and one other matter, the prenuptial agreement itself calls for a final hearing because it's silent as to liability for fees and the order on the prenup reserved on fees. So, A, remand for a fee hearing, remand for a final judgment. B, as the brief set forth clearly, I think reversal is necessary to comport the procedure in this case with the procedure followed in all other divorce cases in the state of Florida.
That being that the alimony determination is after equitable distribution.
That's correct.
My question with regard to that issue is there was the companion appeal. I mean, that award was appealed separately.
Yes, ma'am. I
And-
believe it was joined with this appeal for purposes of traveling together.
With regard to that appeal, I went back to review the brief in that case, and there was, that argument was not made in that appeal, that, that it was improper for that reason, meaning that alimony should not have been determined prior to equitable distribution. That argument was never made, and if it was never made, when it could have and should have been raised in that appeal, which was appealed first, why is it not waived here? Why?
Well, that gets us jumping ahead to our reply brief responding to the wife's statement that we failed to preserve that issue on appeal, and understand I did not do that appeal on the alimony issue, which gets us into our argument that it was fundamental error, that it was technically preserved by the suggestion of bankruptcy, because that effectively stayed equitable distribution of assets, which had a fortiori stayed alimony, because what the trial court could not consider three of the factors that 6108 says you have to consider on alimony: the financial resources of the parties. That includes both marital and non-marital and premarital assets and income.
Well, let me ask you this. I mean, this was a short-term marriage, correct?
6 years.
Well, in terms of the case law, a short-term marriage, and there's a presumption against alimony in a short-term marriage. So how do you overcome the preservation issue and the fact that there's a presumption against the award of alimony in a short-term marriage?
Well, I also want to rely on the, I can't pronounce it properly, probably, but is it the Toiberman case that says where a wholly illegal procedure is followed, that is something prohibited by statute, that the error is preserved. And with respect to alimony that could have been awarded, should have been awarded, we would like to have awarded at a new trial. We do have bridge the gap. We do have rehabilitative. The record that I reviewed is absent of evidence as to how much each party spends each month at the time of trial and how much each party earns each month. The wife did stipulate to ability to pay, but the need was not determined. The need cannot be determined until after the assets have been distributed by statute. And that is the controlling case law that the trial court had when this matter went to trial. In the event it is remanded for another look, we believe that you still have lump sum, you still have rehab, and you still have bridge the gap.
Was a rehabilitative alimony plan presented at trial? Isn't that a...
No, there was not.
Okay, so...
In fact, my client, as Your Honor probably is aware, did not go to the alimony trial, so...
Probably hurt his chances at trial since he was the party petitioning for relief, wasn't it?
No doubt about that, and I wasn't there, so I don't know.
The record indicates that he knew the date and he was instructed that he needed to be there.
The record does state that there were emails between him and the judge's assistant to that effect. That is correct. I make no excuses for that. He is saved again only by fundamental error and the failure to follow the statutory requirement that equitable distribution be tried first. And so lastly, I would ask for a new trial on the equitable distribution, because here again, it just wasn't done.
Well, why would there be equitable distribution anyways? I thought there was a prenuptial agreement. You had a trial on the prenuptial agreement that basically said what's mine is mine, what's yours is yours, and that's how it all turned out, that all the properties remained in the individual names and the agreement was binding, and there's really nothing to distribute. I think the judge awarded your fella some personal property that his ex-wife had somewhere, record that she paid him 19 grand for, I forget off the top of my head what it was for, but that was the extent of the equitable distribution. You keep talking fundamental error. There's a presumption against permanent alimony here. He didn't present any evidence at the alimony hearing. The equitable distribution, there really wasn't anything to equitably distribute based upon the determination that prenuptial agreement was binding. You know, fundamental error goes basically down to the core of the case, and it seems like the core of the case that this is the correct result.
Well,
Regardless of the procedure perhaps being backwards.
Well, Your Honor, you may be correct. I'm like you, though. I'm only reading the record because that's all I have.
As we are too.
And the wife's last financial affidavit on the record, page 340, which is in the record, it says that there's a SunTrust money market account of $119,000, and in the marital, non-marital, it's not claimed to be non-marital. There is a SunTrust checking account of $71,000. That's not claimed to be non-marital. There is a Lexus LS460 vehicle, which is marital. Those three things were not distributed. There is no valuation date selected by His Honor, Judge Beck. There is no identification of any assets that were distributed under the prenup or outside the prenup. And, you know, one thing that comes to mind is, for example, and Mr. Poole did object in the record when he asked to cross-examine. The Judge Beck told him, your 2 hours is over on the equitable distribution trial. He did not have an opportunity to get into the enhancement in value of the wife's assets that was provided through his efforts. And page 4, which is page 20 of the record of the prenuptial agreement, in paragraph 4, it's kind of curious the way this prenup is crafted. It excludes for each of them, but going to the wife, all property acquired by Julie out of the proceeds or income from the property owned by Julie, or attributable to appreciation in value due to the efforts of Julie. So you see, for example, her medical practice, which there's extensive evidence to be offered with respect to the work that the husband did to change her contract with the hospital, get her a better job, move her income from 200 grand to 900 grand. This enhancement in value of that asset, for example, by Erik's efforts, is not excluded by the prenup. So we don't have a single asset identified as covered by the prenup or excluded by the prenup. We don't have any disposition of these three assets that the wife admits in her financial affidavit are marital. So we believe the case should be remanded for a full trial on all issues, at the very least equitable distribution of the property, at the very least a fee hearing, at the very least a final judgment.
Let me ask you a question as far as the fundamental error analysis and your proof that the result would have been different had the court followed the procedural process of the equitable distribution first. Are we to assume that your position is going to be, we should also take into consideration that we assume your client would attend the alimony hearing?
No, I think you should assume that he had an obligation to. And you should assume that that assets were going to be distributed to the husband, thereby nullifying his need for alimony. You see, the judge found that he did not have need. I disagree with that finding on the facts because he had $40,000 in income going into that trial, as I see the record, versus $946,000. I think that's a disparity warning, some bridge the gap or temporary alimony. But his need...
And the only evidence that I saw that the judge relied on was his salaries over $100,000.
From years prior.
Well,
Not as of the date of trial, it was 40,000, I think the record reflects it was
Did you show up
40,000.
at trial to present that evidence?
I believe it was in the record, however. But my real point is that his need only increased as a result of the equitable distribution trial because no assets were distributed to him, you see. So there was no income producing assets, there were no assets distributed to him that could have been sold to provide him with support. There was the monetary assets were not distributed. The car wasn't given to him to be sold and the like. So if anything, the need was, or the lack of need was found too early because his need only increased after he did not receive any assets under the 2-hour trial in which there was no evidence presented as to any assets. If you read the pathetic record, it's there's no asset identified, no numbers, no chart.
I want to go back to your fundamental error argument. And going back and reading that issue in your initial brief, that I didn't see that fundamental error was raised in your initial brief with regard to the equitable distribution.
No, I raised it in the reply brief, ma'am.
You can't raise for the first time an argument in your reply brief and have us consider it.
Well, it was raised in response to their allegation that the error was not preserved, and so we stated, well, it did not need to be preserved via an objection because it's fundamental.
But you have to raise fundamental error in your initial brief in order for us to consider it. Even answering their argument by saying, okay, if we didn't raise it at fundamental error, it isn't sufficient to preserve the error, because you can't raise fundamental error for the first time in the reply brief.
Well, my only default on that would be that the suggestion of bankruptcy operated as such. I'll reserve the rest of my time unless you have further questions at this moment.
Thank you.
May it please the court. My name is Sheila Ennis, and I'm here on behalf of the Appellee, Julie Schneider. This case involves a 5-year marriage and a 5-year divorce. It's now the subject of 2 appeals brought by Mr. Poole. It's very extraordinary given that this short-term marriage produced no children and has a prenuptial agreement that even our opponents on appeal are not contending is invalid as written. The theme underlying Mr. Poole's case is that he wants money from our client. The problem is there's no record support to give him any. He claims to be in financial need, but by his own testimony, he hasn't filed a tax return since 2010. The only evidence before the court was he was making 6 figures consistently throughout the litigation. The last financial affidavit he filed was May of 2013. So
let me ask you about your opposing counsel's statement in his argument that there was a $71,000 account and a $119,000 account and a Lexus automobile that was quote-unquote marital property, I guess, and not distributed by the judge in the proceedings.
There was extensive testimony about these things in the first 3-day trial on the prenuptial agreement. The Lexus automobile was titled to the wife, and therefore that would remain in her, because title controls under the prenuptial agreement, that would by the self-executing prenuptial agreement be distributed to her. It was acquired during the marriage, and perhaps that's why it was checked as quote-unquote marital property. The prenup had not been determined. The bank accounts, the testimony was uncontroverted at the prenuptial trial that by the end of 2009, there was no longer a joint bank account. It had been closed. So again, title would control on those assets as well. There was nothing to distribute, as Judge Beck found. I think it's very difficult for Mr. Poole to come forward and say he's entitled to financial relief from our client when he is refusing to give financial documentation demonstrating his need. He says he is financially bereft, and he did indeed go into bankruptcy at one point, but that was a Chapter 13 reorganization, not a liquidation. He gets to keep his stuff, his townhouse, his cars. The single largest debt he sought to discharge in the bankruptcy was the $100,000 he owed our client under a series of promissory notes. So now he's discharging his obligation to pay her, and all the while continuing to press forward to seek to extract money from her in the divorce court. If he's making $120,000 a year, $130,000 a year, and he's not filing tax returns, his gross is his net. He kept 100% of those funds. Notwithstanding his failure to demonstrate need, our client has contributed about $60,000 towards his attorney fees. By stipulation, almost $30,000 of it was by stipulation just to get this thing over with. They're playing her like a lottery ticket. They're determined that she's going to pay off if they just keep at it long enough. The prenuptial agreement is valid. Judge Beck found that after a 3-day trial that turned into a 3-day trial because they wanted to bring up the issues of equitable distribution over our standing objections. For a day and a half, Judge Beck heard equitable distribution, which there's kind of an argument that equitable distribution was not in fact tried last but was tried first, because Judge Beck lived with this case for 3 years. He went into the alimony trial not in a vacuum. He went into the alimony trial having heard about every piece of real estate, a day and a half on bank accounts. He knew the terms of the prenup intimately, so Judge Beck knew what he was doing when the alimony trial went down. Again, it was on Mr. Poole to show up if he had something different he wanted to present. If he wanted to update his finances and show that 2014 or 2013 was not quite as good a year as 2012 and 2011 and 2010 were, it was on him to do that, and he boycotted that trial at his peril. Now we come into the equitable distribution trial, and our opponent is saying, it's the first time that I've heard this, that we need to remand for a unified final judgment. I don't think it's necessary. While it would be nice to have one judgment, it's not only judgments that are appealable, also final orders are appealable as well. And the equitable distribution order disposed of all remaining issues between the parties. Even the amount of the charging lien was a liquidated amount. So there was nothing more to be done, and certainly all the disputes between the parties were taken care of. Mr. Poole was given 100% of the time at that equitable distribution trial. We had rested our case. We gave him all of it. And he spent the whole time arguing, and if you read the hearing, Mr. Smith repeatedly said, will you please put on evidence? If we're going to go into argument, please put on your evidence. This is your time to do that. He didn't do so. It was on him. If he wanted affirmative relief in terms of attorney fees, he should have done something about it. We were not seeking affirmative relief at all at that hearing. The judge adjudicated everything that needed to be done. So yes, while it would be nice to have one unified final judgment, the judicial labor has ended. Every single order is before this court now, and there is no point to be served in remand. To Judge Lambert's point, all of their claims of error are based on procedural error. They don't like that 61075 subsection 9, the judge flipped them around, although did he really when you look at the record? There's no prohibition against trying alimony last. It may make more sense, or alimony first. It may make more sense in an ordinary case without a prenup and a judge who doesn't know the lay of the land to do it that way, but there's no prohibition. And the construction they want this court to put on 61075 subsection 9 would render Title 11 362 subsection B of the U.S. Bankruptcy Code meaningless surplusage, and that is repugnant to rules of statutory construction. It says the proceeding can go forward on the dissolution of marriage itself. It can go forward on spousal support obligations, and with him saying that it automatically stayed alimony, that legislation is completely wiped off the books. Now, because they didn't raise this until the first time in their reply brief, I was not able to put together something, in a writing for this court. I'm not sure that I should have to address it, but certainly the bankruptcy courts are applying 362 sub B and its exceptions to the automatic stay literally and as written, and they are not finding, if this court does its own research, they are not finding that equitable distribution and alimony are always so intertwined that you have a de facto say of alimony regardless of the language.
Was the trial court given the opportunity to correct any error via motion for rehearing?
No, and that's another problem too. They claim in the equitable distribution trial that there was not any findings of the actual assets and liabilities being distributed. Of course, that would have had to be brought to the court's attention by a timely motion for a rehearing, and there was not one done. So while that could be reversible error in some cases, it certainly is not fundamental error, and that's been held in a number of cases. As far as
What
the,
about the motion for rehearing as far as the alimony, the ruling on denial of alimony?
I didn't recall that there was one.
There wasn't one filed.
I'm sorry?
There was not one filed.
I didn't recall that there was one. And on the partial final judgment of the prenup, there was a motion for reconsideration filed while Mr. Poole had counsel, Clayton Simmons, but he filed it pro se. Mr. Simmons was preparing to withdraw. And the motion for reconsideration, this court can call that a motion for rehearing. The case law says you don't have to be bound by a bad title on that document, but it was filed 23 days after entry of the judgment, and it is untimely. And the law is very clear that untimely motions for rehearing are a nullity. And that was a judgment. That wasn't an interlocutory order. The other thing I wanted to point out is that, again, I meant to return to Judge Lambert's point. If we take all these procedural complaints and we say, okay, Judge, you got it all wrong, go back, you're not going to have a different outcome. In the end, lo and behold, there was nothing to distribute outside of the prenup. Their sole argument aimed at the prenup on appeal, I guess all the other ones have been abandoned, is that it was changed by course of conduct. But they didn't even tell this court in the initial brief that this is governed by a Georgia choice of law provision. And under Georgia law, and I updated my case law yesterday, under Georgia law, there is no criteria for determining a prenuptial agreement to be unenforceable for any reason other than to meet the criteria in the seminal case of Share v. Share. And
There was reference to Georgia law, but was the trial judge ever given the actual authority via Georgia law that he could effectuate the relief that the appellant was seeking?
Judge Beck certainly was made aware of Georgia law. He cites to one of the cases in the partial final judgment ratifying the prenup, which is Mallon v. Mallon, and that had to do with whether the element of foreseeability exists in a case, and so the judge looked to that one. He also described the share factors. Dove v. Dove, I can just speak for myself. I did provide that case to Judge Beck. He did not cite it in his partial final judgment, but that case, Share v. Share, was 1982. In 2009, Dove v. Dove came out, and the Georgia Supreme Court, they sounded quite fed up. They said, stop with the creative challenges. We have never said that share is some of the factors you can look at. They are the exclusive criteria by which enforceability of a prenup can be measured. That's it. And the case in Dove involved whether there were the right number of subscribing witnesses on the agreement, whether there was a marriage, a contract in contemplation of marriage versus divorce, and all these semantic things. And the Georgia Supreme Court said, enough, stop. And I did, as I say, update that even as of yesterday. By the time I got to Amjur, whether you can modify by course of conduct, skips right over Georgia, goes right from Florida and on, to the next one. Not to mention, even if as a matter of law, that would suffice to set aside a prenuptial agreement, after a day and a half of trial on the prenup, Mr. Poole's own expert witness, Adam McGill, accountant, said, you know what, the way they live their financial lives is consistent with the prenup, not an abrogation of it. I was going to go into Mr. Poole's attorney situation. I think it's been fully briefed if this court has any questions about it, but I just want to touch on the fact that he's now in his fourth lawyer of record. He's filed a notice of appearance below, wants to try this thing over again. There's two other attorneys off record, Cheney Mason and Robert Branson, who've never filed appearances, but who are discussed behind the scenes, supposedly giving advice and counsel. Mr. Poole has never been without a lawyer, if he wanted one. Except for two occasions in 2011, at the beginning of the case, every time he has asked for attorney fees, he has been awarded attorney fees. The last attorney, Don Nichols, was on the case for 6 weeks and gave him a refund. So money is not the reason that he's without counsel. My client has contributed $57,500 by stipulation and court order. I think it's disingenuous to say that he's been without an attorney at any point in his proceedings, especially in 2013 or 2014, based on early denials in 2011, and the court later actually awarded fees. I believe I've covered the points I wish to make. If you have any questions.
Nope, thank you.
Thank you for your time.
And counsel, you have a little over 3 minutes.
Thank you, Your Honors. I would note that we do have an appellate fee motion pending. And with respect to the order being appealed here today, it doesn't have the word final in front of it. It could be interpreted to be such, but it doesn't say it's a final order. The order bifurcating this case, Record 367, says that the court will first rule on the issues concerning the validity of the prenuptial agreement and whether or not the agreement was amended or changed. And all the prenuptial final judgment did on December 21, 2012, Record 1679, order and adjudged 1. The prenuptial is valid and enforceable, and the parties are ordered to comply therewith, and then reservation of jurisdiction, including alimony and fee claims. So the prenuptial didn't distribute any assets at all, and no assets are identified. Even the financial affidavit assets that counsel states were testified to are not distributed or eradicated in that prenuptial final judgment or the order on equitable distribution. And finally, there is an order granting former wife's motion for leave to sell the Georgia house, May 6, 2013, Record 1736, that says the court will take any sale proceeds from a home into account in the event the court determines that former husband is entitled to any equitable distribution or other monetary award at the conclusion of these proceedings. That wasn't mentioned in the order regarding equitable distribution either. So what we have is, with all due respects, a total failure to distribute any assets to anyone, and it's even in the wife's interest that she receive an order adjudicating title to the assets that she assumes are hers today, but there's been no order so stating. Everything is still up in the air from my point of view. We thank you for your time and attention and wish you a good day.
Thank you.